effectively through the auction. It's just like if there is a property which we look at charging order, and if it's put to sale, if a property is put to sale to recover proceeds or debt, you can't, well, you can, unless you private sell it by private arrangement already. Otherwise, when it's put to auction, then yes, you have to, you can go to the auction to buy it as well, right? Another party, whether it's the judgment creditor or someone else. Okay, I think we'll get a start again. Okay, then we actually only have a few more slides to go. Okay, after that, that's Q&A session as well. Okay, the next enforcement method we are going to look at is charging order. Something very commonly used where the judgment debtor has property. Okay? It can be on other assets rather than land, but most likely it's a real estate property. Can also be used on stocks, shares, or unit trust. Okay. So one question during the break was, well, do you have to use enforcement methods every time? No. If the judgment debtor, after the judgment's handed down, the judgment debtor pays what's due to the judgment creditor, no, there doesn't need to be enforcement action. All these different methods of enforcement is assuming that the judgment debtor fails to pay, right? And you may notice that some methods, after we gone through every one of them, you may notice that some of the methods may be more effective than others in recovering money. And some are more to, well, sometimes people argue that it's used to give pressure, right, to the judgment debtor rather than really able to recover a large amount of money. Okay. So charging order under Order 50 Rule 1. Okay, where the judgment debtor owes a beneficial interest in assets such as land, stocks, or shares, or unit trust. The creditor makes an ex parte application supported by an affirmation. The affirmation would identify the judgment debtor, meaning, well, in our case, the defendant, the land or other assets to be charged. Should also verify that that particular or those particular assets belong to the judgment debtor. Right? Again, if it's not the judgment debtors, it should not be held under the charging order. Okay. So you get a charging order nisi. Again, that's provisional. The charging order nisi is served on the debtor, giving him at least 7 days' notice of an appointment for further consideration. Okay? Giving him, as in the judgment debtor, 7 days' notice at least. If the order is made absolute, it will stop or prevent any dealing in the property of the debtor. If the property concerns land, the order will be registered at the land registry. Well, once you register something on the land registry, then anybody doing a land search will see that charging order on the register. Okay, so it's telling everybody that, yes, there's a charging order against this property, do not deal in it. That's not the end of it, right? Although you say, yes, it's a charging order, at the end of the day, what you want to get is money. So after you get a charging order absolute, you will make an application for an order for sale. Okay? And an order for sale would be applied, there will be an application made for an order for sale by the judgment creditor as a way to enforce the charge. On that order for sale, then they would specify what is to be sold, how, and how the proceeds will be applied or distributed, so to speak. Because when you think about it, right? Let's say James won as the plaintiff won at the trial. He got a judgment sum of 5 million. Well, let's say the judgment debtor doesn't pay. James applied for a charging order against a property of the judgment debtor, which is worth 10 million. Okay, just say 10 million. So after they get the charging order nisi, then the charging order absolute, James is going to apply or make an application for an order for sale of that property. And if the property gets sold, the expenses used for the sale or advertising will be discharged first. Then James may be paid the 5 million owed to him under the judgment, and the remainder, guess where it will go to? The judgment debtor, right? He owns the property. So we just want to get the money on the judgment sum or judgment award. So after that, the remainder of the balance will go to whoever is deserved. So for example, if there's another mortgage before James, then that will have to be paid off first before James can get paid. So it depends on what we call priority. Prohibition order, a ban from leaving Hong Kong. Okay? Prohibition order under Order 44 capital A, Rule 1, and also Section 21 capital B, High Court Ordinance. It's an order by the court to prevent a judgment debtor from leaving Hong Kong. The creditor can make an ex parte application supported by an affirmation. A sealed copy of the order is served on the judgment debtor, if traceable, and on the Hong Kong immigration authorities, so they cannot leave the border from any border, right? Because whichever point of entry or exit to and from Hong Kong, the immigration department is in charge, right? Whether it's en route to China, in Shenzhen or wherever. The court will only make the prohibition order if the judgment creditor can show that there's probable cause to believe the debtor is about to leave Hong Kong, and that, as a consequence of him leaving Hong Kong, the satisfaction of judgment is likely to be obstructed or delayed. It must be shown in the supporting affirmation that the debtor's departure is imminent, is upcoming, or immediate, fairly immediate. Ning Diep and Luigi Farini. Also, if there's evidence that the debtor intends to depart Hong Kong with a sense of permanence, so not just leaving Hong Kong for a weekend trip, intending to leave Hong Kong for good. Apart from the methods that we've gone through tonight, there are other methods that may be used to place pressure on a defendant or debtor to pay, including a threat of bankruptcy proceedings or winding up proceedings if it's a company. If the defendant, well, for bankruptcy and companies is quite easy, right? If you can show that the defendant or judgment debtor owes you a certain amount of money, right? For bankruptcy proceedings, all you need is 10,000, right? 10,000 statutory, and then you can have issue what we call a statutory demand, and if they do not pay, you can proceed with bankruptcy proceedings if it's natural person, or winding up proceedings if the debtor is a company. Okay, so that's quite a bit of pressure, right? Because it's a big deal. If the defendant or debtor is covered by insurance, the judgment award and costs are normally paid by the insurance company. As with what we said during when we look at pre-action considerations, a prudent plaintiff should ascertain whether a defendant is worth suing before commencement of proceedings. Okay, because it's not for spite; it's to get or recover compensation. Right, that's the purpose of legal proceedings, or main purpose. That's pretty similar to what we looked at last time. Right? Reflection activity 1. Construct a flowchart outlining the whole of civil procedure you have learned, starting from the letter before action to the end of the trial and all the enforcement actions. Compare your chart with those of your classmates and make improvements where needed. You can refer to the sample flow chart on pages 94 and 95 of the course manual. Okay, so I guess that's similar to what we did last time, right? Do you want to draw on your own, or do you want us to just go through it quickly together? No response. Okay, well, why don't we just quickly go through it again? Where do we start after pre-action consideration? When we start, how do we kickstart? Let's assume it's a reaction. Where do we start again? I think you can all tell me. Writ of summons, yes. And then? The other side, that's by the plaintiff. And the other side has to file. The defendant has filed. Can I have more response? Yes. Yes, thank you. Okay, acknowledgement of service from the defendant. And then, let's assume is a... Let's put it as this as the quick revision, right? Although we have revision next time. So, writ of summons is... What do we call writ of summons? And because we are towards the end, okay? It's a fairly... Because I think I went through the initial bit a bit too fast. So just take it as a revision. This is our last proper lecture. Okay, so writ of summons is a type of... What's the document called? What? Writ of summons is not a pleading. Originating process. Okay? What other originating process? Just stop, forget about your menu. Just think of this as a quick check revision. Okay? No marks awarded anyway. So, okay, just forget about your menu. Okay? So, it's an originating I think I lost the... Okay. It's an originating process. What other types of originating process are there? Writ of summons and OS, which is originating summons and originating motion, and one more, petitions. Okay, so 4 types of originating processes. Okay, so let's say it's a writ action. Writ action, so it's writ of summons, and then you told me is acknowledgement of service, right? Is it a pleading? No, good. No, it's just to acknowledge. It's acknowledgement of service of writ of summons. Okay. After that, assuming, okay, generally endorsed writ and specifically endorsed writ. Which one has the statement of claim? Specifically, right? The one with S. Specifically endorsed writ is the one with statement of claim. So let's assume we have a generally endorsed writ, which only contains an endorsement of claim. So after AS, what do we have? The statement of claim. I just told you no statement of claim yet, right? Statement of claim by the plaintiff. After statement of claim by plaintiff, then what's the next pleading? Defense by the defendant, right? And then what's the next pleading? Statement of claim, defense, and then reply. Plaintiff always have more say, right? For some reason. Okay, so reply by the plaintiff. After that, can you have more pleadings? Yes, but you would require leave of the court. Well, they're not as important. So rejoinder and surrejoinder. What else can be? You just try to absorb as much as you can and try to answer as much as you can, just as a quick revision for yourself. So what else can form part of pleadings? Further and better particulars. Okay, requests and answers. So the answers are the content. So answers to further and better particulars can also be pleadings. They are to supplement, right? Because some parts of the pleading is not clear. That's why we have further and better particulars. After that, that is the pleading stage, right? That is the pleading stage after the reply. Certain time, I think it's 14 days if it's reply. If the defense and counterclaim is the last pleading, then it will be 28 days. Now, after the pleading stage, what comes next? Discovery under order Pleadings are under Order 18. Okay, pausing that, let's say, what type of revision, remember? What type of applications can the plaintiff make to shortcut the whole process and win the action? First, which one comes first? Okay, along the timeline, think about the order numbers. Okay, after the writ, Order 13 for judgment in default of acknowledgement of service. Okay, judgment in default of AS, Order 13, right? Although pleadings is Order 18, but here we're talking about if where the plaintiff has chance to shortcut. Okay, judgment in default of AS. Order, well, here we have Order 19, judgment in default of defense, right? What's in the middle? Order 13, Order 14, what's that? Summary judgment. Summary judgment saying that what's the two limbs that you can say for the plaintiff to win? The plaintiff is saying there is no arguable defense and that there are no triable issues. Okay, so well, how come in this order? Why can't we have? How come we can't have the judgment in default of defense earlier? Well, because here that's where it normally takes place. Judgment after, if the deadline for AS has expired, then the plaintiff can apply for Order 13, judgment in default of AS. If the defendant filed the AS, but we think they have no case of defense at all, we apply for Order 14. If they proceed and expire, and by the time of expiry of defining the defense they failed, then we apply for Order 19. Which one is easier to have a judgment for the plaintiff to get a judgment in default of AS or defense or summary judgment? Which one is easier to get? Default judgments are easy to get because it's purely procedural, right? It's a high hurdle to say, it's a high hurdle for Order 14 to say the defense case is rubbish, right? It's much harder to prove that they have no case. Okay, after that you said, okay, let's assume now you were right, pleading stage closed. Next stage, discovery under Order 24. What generally is involved? Automatic discovery where you exchange list of documents. Okay, list of documents, remember your Schedule 1, Part 1, where you have those documents in your custody, power and control, and you do not object to producing them, meaning giving photocopies. Schedule 1, Part 2, yes, I have those documents in my custody, power and control, but I object to producing them because they are privileged. Okay, privileged. So privileged because they are either subject to litigation privilege, solicitor-client privilege, without prejudice communications, public interest immunity, okay, or privilege, okay, PII. So after that, what normally happens? Okay, forget about security for costs. They can happen anywhere, right, along the litigation. What would you next prepare again? Last time we said, after discovery, you probably start preparing, because everybody has all the evidence, all the documents now, so you further prepare your evidence, which would involve witness statements. right? Those are very important nowadays because look at the EIC, look at the evidence in chief during the trial process. You are not allowed to elaborate. Let's say I had Angela as the plaintiff's witness. She is not allowed to elaborate in the evidence in chief. She is supposed to have put everything in her witness statement. When I try to lead her in examination in chief, I can only ask her to adopt. Court very rarely allow for elaborations nowadays because everybody should know everybody's case and evidence. If I allowed her to elaborate something or give more than what's in the witness statement, then that's ambush also, right? That's also ambush and surprise. So not allowed to do that. So witness statement is very important, as well as if I need expert, that would be expert evidence or expert reports, right? All about evidence, everything about evidence in Order 38. Okay, so as we get closer to the trial, we may have some case management summons. We may have a case management conference. Once we get to the CMC, it's milestone dates. Those dates that are very fixated and the court very unwilling to move on. Before the trial, what do we have? 1 or 2 months, 2 or 3 months, two months before the trial. Pre-trial review. Okay, pre-trial review, smooth out any matters that are not dealt with yet. And then we have the trial. Right? And then we have the trial, and then we have enforcement issues, right? So those should be around or about what is in your course manual, roughly. Any questions? Anything missed? Thanks. I don't think I have any additional stuff to show you this lecture. No. Okay, are we the landlord-tenant scenario again? What else do we have? Okay, we get to a scenario again of the landlord-tenant that we have been dealing with in the last 2 lectures. Remember the 20,000 per month tenancy? About the scaffolding and maintenance outside the premises. Okay, if I get bigger. Right, what do we have to do with it? So the case between the landlord and tenant was ultimately tried. Okay, and judgment in favor. What judgment was given in favor of the plaintiff, landlord? So what did the plaintiff ended up getting? Order of possession to landlord of the shop premises. The tenant has to pay rent in arrears of 40,000, which is 2 months, to pay mean profits in the sum of 20,000 to L. Now, mean profit is it's pronounced mean profits. Mean profits are, well, the landlord is saying the tenancy has terminated, but the tenant is staying on. Okay, we don't call that rent because for rent to be paid, that must have been during the tenancy. So for this de facto use of the premises beyond the tenancy, we call it mean profits. That's all it means. Number 4, interest on the said sums of 2 and 3 accrued from their respective outstanding dates. So that's the pre-judgment period, right, to the latest date by which the tenant could have accepted the sanction offer. So there was a sanction offer by L at the landlord at the judgment rate. Interest on the said sums accrued from the latest date to the date of payment. Okay, see, this is a prime good example of, oops, excuse me, oh, I can't hold on to it. Here. So interest, remember I gave you a timeline? Okay, Okay, read. This is, what's the SO or SP? Must be SO, right? Because it's by, yes, it's by plaintiff. SO, let's say this is the last day. So from reading at that facts, you can see that from here to here, it is normal judgment rate of interest. And from the next bit, it is the enhanced interest rate. From the last day, the SO could have been accepted. Enhanced. In this case, is it, how much is it? 5% more, is it? Enhanced rate. So let's say that's judgment rate is 8%. 5% above judgment rate. So 8 plus 5 is 13. Between here to here. Right? That's the prime example of how the sanction offer or sanction payment rate works. Okay. Cost to the landlord up to the latest date, again, at which the SO could have been accepted, to be taxed if not agreed. Cost to landlord on an indemnity basis from after the date to the date of payment to be taxed if not agreed. So this is also where the indemnity basis works, right? Because this is a punitive period, right? This is where the offeree is punished, the period for which the offeree is punished. So this is also where the indemnity basis works. Remember, cost on the indemnity basis where it's wider, almost everything is in, unless absolutely unreasonable. Interest on cost for 4 at the rate of 5% above judgment rate. Okay, to the date of payment, actually. So indemnity basis. Up to the date to the date of payment. So even beyond the trial. Okay, and this is all on enhanced interest rate. So, ouch. So here, the top part here is only to show you what the implications can be like in a sort of scenario, factual scenario. Okay, it's not really. It's only telling you. It's only giving you an example, like in your manual, right? So you can see what it means. Okay, then after the judgment, the tenant delivered the shop premises to landlord but did not pay the monetary judgment. Landlord discovered that the tenant set up a car washing business in another shop premises and jointly owns a residential property with her spouse. Tenant has a bank account with HSBC, but the landlord has no knowledge of the balance of the account. What advice will you give to L for the enforcement of the judgment? So where do we start? Okay, we've looked at quite a number of methods, right? Just have a quick, very, very quick review. Oral examination to find out about financial position or capacity, right? Assets, liabilities, income, etc. Right? So you can orally examine the judgment debtor. Writ of FIFA to go into judgment debtor's premises to seize, okay, to seize goods by engaging a court bailiff, not by yourself. Okay, and then if the debtor doesn't pay, you sell the goods to recover some money. Bear in mind that, of course, yes, you can use a writ of FIFA or even a charging order. Sometimes you may not get the full amount, right, still, but you're trying to get as much as you can. So that's the writ of FIFA. Garnishee proceedings if somebody else owes the judgment debtor money. Charging order if the debtor owns land, stocks or shares or unit trust. Prohibition order is for banning or preventing the debtor from leaving Hong Kong. Okay, so from that quick look, what can we do? Any suggestions? Okay, so what are we after? Money, right? We're after money here. Car washing business, what can you do? So Tenant has now set up a car washing business in other shop premises. Let's just look at the car washing businesses. What can it have? Well, I would assume the tenant doesn't own the property, but there may be machines, yes, machinery, maybe some valuable machinery in the premises. So what can you use? Writ of FIFA, okay, under Order 47, I think. Okay, so you can engage a court bailiff to go and seize the machinery and sell them, okay, if the T still doesn't pay. Of course, yes, he's allowed to retain some items like tools of trade, but only to the value of 10,000. Right. So here we have 60,000, right, that we're trying to recover. Is that correct? Yep, I think it's 60,000. Okay, so, okay, that's the car washing business. How about the residential property? How about the residential property? Charging order? Yes, so charging order nice eye, absolute, and if still doesn't pay, order for sale. Okay, after you have the charging order, what should you do? Register at the land registry, okay, to stop or to warn other people that there's a charging order. How about the bank account? Garnishee proceedings. Okay, garnishee proceedings. Who's the garnishee? HSBC is the garnishee, right? It's the third party who owes T the money. But you don't know how much balance is in the account. So you would ask under order, or you can choose whether to apply under Order 48 or Order 49B for an oral examination. Okay, to find out his financial assets, including the balance. Right? You can even ask him to bring documents, remember? Okay, so any questions here? Question 3, how can a prudent plaintiff protect against a defendant that is dissipating assets so as to render any judgment futile? Futile means fruitless. Okay. So if you know the defendant is trying to dissipate assets, what can you do? What kind of order? It's an order, all right, but what kind of order? You would have covered it in your pre-action considerations. It's applying for a Mareva injunction. Okay, Mareva injunction. Mareva injunction spelling. Mareva injunction. That injunction would have the effect of stopping or preventing the judgment debtor to dissipate or sell off or dispose of assets that are within this jurisdiction. If you want to apply for an injunction, Moravian injunction, that stops the defendant from dissipating any assets anywhere in the world, it's called a worldwide Moravian, but it's much harder to get. Okay? But a normal, typical Moravian injunction is about assets in Hong Kong. Explain how the procedure of examination of a judgment debtor under Order 49 operates. I think we've gone through that. And the next question is about which is more effective, 48 or 49B. So looking back at our comparison table. Okay, so, well, first of all, the first question was about 49B. So again, ex parte application, set date for hearing, notify the defendant, ask him or her to bring relevant documents concerning their financial position to the oral hearing. Okay, examination conducted before a judge, must answer all questions put to him. Okay, defendant will be made to make full disclosure of his financial position at the hearing. Okay, and also there is the power of arrest and imprisonment. So it's up to you to say, do you think Order 48 is more powerful or Order 49B? Right, remember, this one can be applied for against any judgment. This one against monetary judgment. This one heard by a master. This one is before a judge. Okay? But, of course, there's also the difference about enforcing it against individuals as well as company or company directors under 48 and only against individuals under 49 capital B. So it really depends on your factual circumstances. Are you trying to enforce against a company or individual? Right? Do you really need the power of arrest and imprisonment to make him comply? Okay. Of course, having the power of arrest and imprisonment by the judge under Order 49B is quite serious. So it may have more pressure. Right? But there's been arguments about they both flow through because of historical reasons, right? And again, it depends on your circumstances, which one's more suitable. Okay. Any question on that? No, this is for enforcement after judgment. After judgment. Yes. Yes. In fact, charging order is is an enforcement method of debt. So it can be because you have a judgment awarded to you that one person is a creditor and the other is a debtor, but it's also used in every day to enforce debt. Okay, so it may have more use than just enforcing monetary judgment after a trial. Okay, so.
Are there any difference regarding the hurdles or the application fee between 48?
Not that I know of. Not that I know of, but it may take a little while longer because this is before a judge, right?
So would it be generally more powerful to use 49B and
Well, as I said, to put more pressure because there's a judge and there's a power of imprisonment, etc. Yeah, a little bit. Okay, but charging order and garnishee proceedings, you can have it for, well, normally, yes, it is normally, but especially charging order is also used in a lot of mortgagee actions as well. right? When people owe money under a debt and they can't repay, they can also have charging orders as well. Okay, but mostly after judgments. Mostly after judgments. What else? Okay, I think that's it for tonight. Well, it's very early, so I'll stay back for Q&A. First of all, think about whether you have anything you don't understand during this lecture. And then if you want to go back on other previous topics, that's also okay. Well, they don't show, this. Well, they don't show how thick it is, the Hong Kong civil procedure. The volume 1 is about
This thick. No, I'm not exaggerating. It's about this thick. The
first volume here, nowadays, is now this thick. And the paper is so thin that you can see through them because they have so many pages. Okay, that's what I said about Hong Kong civil procedure, what we commonly call as the White Book. Is there anything I didn't show you? I think I've shown you all the bits, extra bits. Well, can you think of any questions?
So for all the civil procedures, is the prerequisite is that you know the address of that person. Like if the person has evaded, like the Zhou Ba, then you have no method.
Zhou Ba is good. He's at your premises. You can get him.
If the person went away, you don't know where to
Oh
find.
yes, it is always difficult if you don't know the address. Right? You can have substituted service, etc., but still, it's a long-winded process.
If someone like owe you money, but then you change the phone number, change the address, you can do that.
Yes, you cannot. You cannot. Well, it's very difficult unless you try and find some private, investigator, right? Yeah, it is a little bit difficult. No questions? You know everything already? Or just too tired? I'm also very tired. I've been in court since 9 something.
What else can I tell you?
Nobody has any questions? It's very early. If you really want to go, I won't stop you. But are you sure you have no questions? Although we'll see each other again next week, won't we? Right? You're welcome to stay back and think about whether you have questions or if you want to be like a study group or whatever. I don't mind. Okay, up to you. Up to you. Oh yes, good. Your question is so important. I'll give you a microphone so everybody can hear. Because every time I have to. It's about the assignment. Okay, question about assignment.
我想問下寫嗰個reference， 即係 cite the case 或者
citation， yes.
citation。咁我係喺答個問題個答案裏面咧，定係另外一版 footnote 裏面再
Okay, let me ask you a question. In the assignment I give you, is there a word limit? Yes, there is, right? The answer is yes or no wise is yes, right? Whenever you have an assignment with word limits, do not use, first of all, to answer your question very quickly, you should put everything, or you should try to put everything in the body, right? You should try to put everything in the body. If you must use footnotes, be sure you don't use it for anything other than strictly the citation. If there's a word limit in your assignment for any subject, please do not use footnotes or endnotes for elaboration. You run the risk of them not getting marked. Now I struggle to decide whether I mark or take into consideration those elaborations. Right? Because if I take into account, it's unfair to the other classmates, because they complied with the word limit. I have had not too many, about 3 students from my other lot that use footnotes for a lot of elaboration. Right? You shouldn't do that. Right? If you give a good answer, actually, you should be able to do that all within the body. But if you put the citation really in footnotes, purely the citation, I won't really mark you down. I try not to, right? Because you're just trying to do your work. But try not to do that. So no elaboration in the footnotes or endnotes. If you must use citation, put the citation down as footnotes, you can. Okay, I won't mark you down. But you should really be able to do that even during the body. Right? I don't expect very, very long-winded answers. I need all the basics there and the cases, and be sure you mention all the rules and all that sort of stuff. Should be pretty basic, right? My assignment is very easy. Right? It's very straightforward. Almost just.
Can I know when is the revision class? Because we don't know which day you want this for.
30th of March is. I'm told it's you guys, right? Yeah. It's the civil procedure, right? 30th March is me. Okay, so that's it. Any other questions? I don't mind. If you have questions about any other previous topics, no? Okay? All okay? Yep, you're free to leave if you finish. I don't mind, it's too early. I really feel too early for me to leave. So if you have other subjects that you want to ask, it's okay also. Right? I don't really mind.